Hello, I am Deepak. Welcome to Weekly Patent News, a show that provides quick updates on the recent activity in the patent world. Last week we covered the ongoing battle between the Supreme Court and the Federal Circuit. Some regard Federal Circuit as a rogue court responsible for distorting the U.S. patent system. This week, the Supreme Court stripped more power from the Federal Circuit. The case involved two pharmaceutical companies, Teva and Sandoz, over a patent related to the multiple sclerosis treatment drug Copax-1. Supreme Court concluded that the Federal Circuit could not second-guess how lower courts interpret claims except on rare occasions. U.S. Supreme Court judgment will favor Israel-based Teva. The move could be a blow for generic drug manufacturers such as Natco, Sandoz, Mylan, and Momenta. Tridim, a patent-holding firm, is asserting two patents against Apple targeting Apple's Safari, CoverFlow, and Time Machine user interfaces. The patents were filed for in 1996 and subsequently assigned to Xerox in 1998. Plaintiffs allege that Apple willfully infringed on the patents as Apple had the knowledge of the patents, evidenced by the fact that Apple cited Tridim's patent as prior art in over 20 patents. In 2008, a firm called Mirror Worlds brought suit against Apple for its use of CoverFlow and Time Machine. Mirror Worlds won an initial $625.5 million ruling in 2010, but Apple successfully appealed and in 2012 had the verdict tossed. The National Retail Federation announced the launch of United for Patent Reform, a new coalition co-chaired by NRF and Oracle and comprised of grocery, hotel, retail, restaurant, and technology associations and companies. The Broad Business Coalition will pursue patent reform legislation aimed at curbing abuse of the patent system by patent trolls. The United Patent Reform Coalition released a letter outlining its 7 core principles. Managing IP has decided to launch IP events aimed at women. The statistics indicate that there is a wide gap between men and women who start careers in law firms and those that made partnership or took on chief IP counsel roles. More than 200 women attended the inaugural Women's International Leadership event in New York last year. We at PatentYogi support this initiative. It is about time more women succeed in this profession. Let's move on to the courtroom section. The Federal Circuit recently issued a decision in the Antares Pharma v. Medac Pharma that examined the issue of whether claims have been properly broadened in a reissue application. The court found that the original patent requirement mandates that newly claimed subject matter be disclosed in an explicit and unequivocal manner in the specification. Therefore, the newly added claims cannot be merely suggested or indicated in the specification. In contrast, the court noted that continuation and divisional applications are avenues for applicants to shift the scope of the claims from one invention to another. California Federal District Court issued a summary judgment order in favor of Mentor Graphics, invalidating all asserted claims of 3 patents asserted by Synopsys. The lawsuit initiated by Synopsys in 2012 involved 4 patents covering synthesis technology. Litigation of the 4th patent is stayed pending an inter-parties review by the Patent Trial and Appeal Board of the United States Patent Office. Any trial on this patent will be postponed until after Patent Office has completed its review. Swiss firm Ethical Coffee Company lodged a complaint in a Paris court against Nestlé for patent infringement with its Nespresso coffee machines. Ethical Coffee makes coffee capsules that can be used in Nestlé's Nespresso machines. Ethical Coffee accused Nestlé of modifying the Nespresso machines to keep competitors' capsules out of the machines with a harpoon device in its new Pixie range, which jams the capsules. In June last year, Ethical Coffee won a legal suit against Nespresso in France when a Paris trade tribunal ruled against the giant in an unfair competition suit filed in 2012. It ordered Nespresso to pay €500,000 to ECC and €40,000 more to cover legal fees. Moving on to the international news, the European Patent Office received more than 273,000 patent filings in 2014, an increase of around 3% over 2013 and a new all-time high. The filings originating from Europe remained stable. There was strong growth from the U.S., very strong growth from China. Korea saw moderate growth, while patent filings from Japan saw a drop. Starting March 1, 2015, anyone filing a European patent application will be able to request validation for Morocco. European applicants and patents validated for Morocco will have the same legal effects there as Moroccan ones and will be subject to Moroccan patent law. Morocco is the first non-member country of the European Patent Organization to validate the legal effects of a European patent on its territory. Turkey started online IP filings. The online filing system may be used for all types of procedures, such as recording an assignment and license and waiving an application. Under the new system, proceedings are expected to be both easier and faster. Canada is fulfilling its undertakings to adhere to the patent law treaty adopted in Geneva in 2000, with an amendment to the Patent Act via Bill C-43. The amendments include worldwide harmonization of national patent formalities, simplification of national patent office procedures, and standardization of mechanisms to help avoid unintentional loss of patent rights resulting from failure to comply with formalities and specified time limits. Intellectual property rights and bilateral investment treaty are key issues on the agenda in the ongoing India-US dialogue on the economic front. Secretary of State John Kerry had a good visit to India recently, and a variety of issues including IP and BIT were talked about. Next week, Obama will visit India as a guest of honor for Republic Day celebrations in India. New patent published this week. Google brings Twitter-style handles to document editing. This takes Google Documents a notch ahead of MS Office, which is stuck up in the PC era. Microsoft invents a projection system for displaying images on skin of robots from inside the robot. Robots do not need to carry TV-like monitors anymore. Apple patented advanced UI gaze controls. Eye tracking will enhance user experience on all future eye devices, the MacBook, and more importantly, for use in your car, in a future gaming console or entertainment system. Apple patent reveals future iPhones may have a joystick built into the home button. A joystick is built into the home button of future iPhones. The joystick is activated by pushing down on the home button. This will improve gaming experience on iPhones. It is time for this day in patent history. On January 23, 1849, a patent was granted for an envelope-making machine, greatly reducing the time needed for the mass production of envelopes. On January 24, 1871, Charles Goodyear, Jr. patented the Goodyear welt, a machine for sewing boots and shoes. Welted shoes have more strength, durability, and repair quality. Thanks for liking and sharing the video. Please subscribe to our channel by clicking the big red button below to receive updates on new videos uploaded every week. If you are viewing this on a mobile phone, please find the subscription link in the description below. Until next time, keep innovating and keep patenting.